we are pleased to have Jordan Cullimore and Rick Plain here from the Utah Office of the Property Rights Ombudsman. This organization is, in my opinion, being a member of a planning commission, of great value to both property owners as well as local governments around the state. They work a balance between property rights and the needs of the community, and I've been involved with them in addition to doing these trainings, also in person, asking questions about various land use things. And so we really appreciate Jordan and Rick coming in and presenting today on the legislative session and really what changed. I got a little bit of a preview of their slides, and there was a lot more stuff there than I thought. And so I won't take any more time, but just turn over the time to Jordan and Rick.
Yeah, well, Jason, so thanks for having us. We're excited to be doing this again. In the going on 8 years I've been with the office, we've been regularly doing these legislative updates with the trust. We certainly appreciate the relationship and the opportunity and the work that you guys do, and for the invitation to come and provide our thoughts on each legislative session. I guess we should apologize in advance that we're not doing this until June. We like to do it when it's a little more fresh in the minds, but scheduling this year just kind of worked it out this way. So hey, summer vacation, legislative update, those things seem to go hand in hand, right?
You bet.
So yeah, just by way of introduction, my name is Jordan Cullimore. I've been with the office going on 8 years. I've been the lead attorney in the office for the past 2 years. I refer to myself as the pandemic ombudsman. And Brent Bateman was the prior lead attorney. I've also worked in Utah as a city planner. So I found that to be a helpful perspective in working with local governments and understanding kind of the difficult work you guys have and the balances you have to keep in mind when you're doing things. You want to introduce yourself, Rick?
Yeah, so I'm Rick Plain. I'm an attorney with the office as well. I've been with the Ombudsman's office for 2 years, and so I did this presentation for the trust 2 years ago, right as I just started. And if Jordan considers himself the pandemic ombudsman, I'm certainly the pandemic attorney in the office because I was there for maybe 3 or 4 weeks, and then everybody went home to teleworking. So. But it's great to start getting out again and to meet with people face to face. But these still are great ways to get information out as well.
Yeah, and I was telling Jason, the trust was doing webinars before webinars were cool, right? So now it's just normal and everyone's used to it. But it's been a fun experience. So. And we always kind of like at the beginning of these presentations, just because we know there's a lot of new faces every year on planning commissions and city councils and even with staff sometimes. So we think it's important to know and understand about our office because we're a resource. We're a resource to local governments. And so we like to make sure everyone knows who we are and what we're doing. This is a page from our website and our About the Ombudsman page. We also did just get an update to our website, so it should look a little newer and cleaner. It still has all the same information. We encourage you to go check out our website. It's there that you can also not only find explanations about legal principles related to land use and eminent domain, but it's there that you can pull the PDF document to make requests through our office. So the Ombudsman's office, we are a neutral, independent state agency. And primarily what we do is we provide dispute resolution services in the area of land use and eminent domain related to property rights. So we typically talk about, there's 3 primary things we do. And there's 2 main dispute resolution tools that we provide: mediation and the advisory opinion. So in the eminent domain realm, when a condemning entity, whether it's a local government or a private utility, if they need someone's property for a public use, then they have to go through a process that includes informing the property owner about our office. And the property owner can request mediation. We can get involved, not to force anyone to do anything, but to help the parties come together and have a conversation. We can get an additional appraisal for the property owner if they feel like the government's offer is not in line with fair market value. And so we basically provide data, we provide information, we provide a forum for discussion. And usually in my experience, all parties involved appreciate having that forum available as a dispute resolution tool when working through those kinds of issues. On the land use side, our primary dispute resolution tool is the advisory opinion. So if a developer or a property owner has a land use application with a local government and a disagreement arises about maybe how a code should be interpreted, or whether or not a certain condition can be imposed or a requirement can be imposed on someone, then any party, the local government or the property owner, or even a neighbor, a third party, can come to our office and say, hey, can you give us a legal opinion about whether or not, what the law says, or how what a court would say about our dispute. So we gather information from the parties. Sometimes we mediate along the way and resolve it that way. And then often we'll also produce an advisory opinion that the parties can use to help to resolve their dispute. The third primary thing we do is provide training like this. So and one thing we like to let everyone know is that we'll go anywhere. So we'll go throughout the state and provide training to local governments, to staff, and we recognize that land use is a local concern. And we recognize that each community, Logan is dealing with things different than Salt Lake is dealing with things different than St. George, Beaver. Every community is dealing with different things. And so we really enjoy going into each community and trying to answer questions and help out in whatever way we can. So, and you can also request training through our website, or just give us a call or send us an email, which we'll put up at the end here. So that's kind of a general overview of our office and what we do. Please give us a call. One of the main things we do is spend time on the phone with people, answering their questions and helping them understand the rules and legal principles and how to approach things. And we talk with the whole gamut: property owners, staff, planning commissioners, city council members, county commissioners, everyone. So let's get into the meat of our presentation today for the legislative update. So here's kind of an overview and list of some of the bills we're going to try to touch on today. For the stuff that we do, and that's kind of what we're going to focus on, is land use and eminent domain, property rights issues, and bills that we thought were interesting and impactful for city council members, planning commissioners, and staff in the area of land use and property rights. So there were two kind of primary and major themes. And they're related themes, and they both, I think, kind of fit under the umbrella and category of growth. Growth is a big deal in Utah, as you all know right now. And so we kind of split it out into, so there were some water bills and there were some land use and development bills. So we'll just kind of jump in and go through them in that order.
All right, so to start off, obviously, water was a huge topic at the legislature this session, and mostly because we have a kind of an emergency situation, right, with our water, and kind of the worst drought that we've had in many years. And so the legislature is tried to look at what can be done, and we have in our code some provisions about what do you do in a water shortage emergency, right? Because water rights are all about first in time, first and right, and it's all by permitting system. But when there's not enough water to go around, is there any consideration for maybe changing some priority of how we use water? And we have some of that in code today, but obviously we haven't had to rely on it much, if at all. And so the state has taken a second look at that by further defining what actually a temporary water shortage emergency means, which is something that's caused by drought, man-made causes, or natural disaster. And what they've tried to kind of clarify or add with this bill is that it has to be a specific declaration of emergency by the governor that's separate from and different from just a general state of emergency that is available to the governor under any Disaster Relief Act. And so the temporary water shortage emergency is specifically declared for that purpose. This bill changed that this declaration can't be more than a year. And then what it does is it changes some of the priorities for how water is used. So the old law was, they kind of had a tiered priority system. So the first priority was, in no particular order, drinking, sanitation, and fire suppression. If it's used by either an individual, a municipality or county, a public water supplier, or the military. So basically, anybody besides a private venture, right? A business, more or less. And then in addition to that, kind of the second priority is subject to, subject to all this above. There was an additional priority for agricultural use, which includes irrigation and livestock watering. And so that might, cover some of those other non-municipal or non-individual residential uses. So that's what the law was. So what the bill changed this year was adding one more thing to that first priority list, which was the generation of electricity. Obviously, that's a very important thing that we want to make sure we've got enough water to, it takes water to kind of, power all of these power systems that we have. And so it's important to have water for that. And it also directs the state engineer to study how maybe we should change this again in the future, because like I said, we haven't had to really put this into place before. And so the state engineer is directed to kind of study, what should we be prioritizing? How should we prioritize it? How do we compensate, moving people up in the line if we need to do that? So that's the change the legislature made with this law.
Okay, so the next one we're going to look at is Senate Bill 110. This was one of the, in my opinion, bigger and more impactful bills of the session in some ways. You see the key takeaway there: it requires local governments to plan for water use and preservation in the community's general plan, or to get ahead of water issues. So it seems like the legislature lately has been really looking hard at general plans as a place to have an impact. You're all aware that a few years ago with SB 34, which we'll talk a little bit more about later, they introduced the moderate income housing element to the plan that you have to have. This year they added another requirement. So up until now, it's basically been land use and transportation have been kind of the required elements. Now there's moderate income housing. Now there's also a water, what do they call it? A water preservation, water use and preservation element to the plan. A water use and preservation element. And so, I listened to the committee hearings kind of that they had on this bill. Senator Mike McKell was the sponsor. He brought together apparently a lot of stakeholders. All the major water conservancy districts were involved, a lot of others. And as he presented it, everyone's really on board with, hey, this is a good idea. And I tend to agree. We go, like I say, we go and provide local trainings to local governments. And one of the things that we've been hearing a lot when we go provide these trainings is, hey, we think we're running out of water. So-and-so over here has this well and it's taking a lot more to get out of it now. We're concerned that if we approve X number, more housing projects, if we approve more subdivisions, that will continue to impact our water levels and we'll start running out of water. The difficulty is they don't have a lot of data or context to go off of to decide, how much more capacity they have, where they have capacity, how to build capacity. And I think a lot of what this requirement does with Senate Bill 110 is it puts eyes on this issue and requires local governments to start thinking about these things in a more strategic and holistic way. So the intent is to bring together the land use element, land use planning with water use and preservation planning, to kind of look at those things together and try to get ahead of the issues. So what does it do? It applies to counties and municipalities with a population of more than 10,000. In other words, it excludes cities of the 5th class and towns. But again, the legislature and the sponsors were very clear that they put that in there out of a concern that smaller communities might not have the resources. But at the same time, they're strongly encouraging every community of any size to be concerned about this issue and to even follow the provisions and have this part of your plan fleshed out so that hopefully you're ready for providing water in your communities as your communities grow. So it requires that water use and preservation element, and it provides that part of the plan has to be implemented by December 31st, 2025. So what does it address? It addresses the effects of permitted development or patterns of development on water demand and water infrastructure. So you have to look at that. Methods of reducing water demand and consumption for existing and future development. And then it has to address opportunities for the municipality to provide for operations to eliminate practices or conditions that waste water. So again, this is one I think the key takeaway is that it must coordinate and be coordinated to integrate the land use plan in your community with the water and preservation plan, and needs to account for the effect of land use category and land uses on water demand, which I think is smart. You know, if you have a community where you're having water issues and water shortages, then you should probably know, you know, how you've zoned different parts of your community and what densities that zoning is going to support, how much water it's going to need. The idea is hopefully that through this planning process, you'll be able to identify those types of things. Some other provisions that I thought were useful to be aware of and get eyes on when you're drafting the plan. The Planning Commission needs to consider water conservation goals recommended by Division of Water Resources and any required water conservation plans. And then you have to look at recommendations for water conservation policies, landscaping options that are water wise. And then you have to review the ordinances and include recommendations for any changes that would to the ordinance. So if an ordinance currently promotes inefficient use of water, you should be looking at that and making recommendations to change that. Consider principles of sustainable landscaping. There's a whole list in the bill and in the statute that outlines what sustainable landscaping looks like. And then consult the water provider if it isn't the city. So coordinate with that entity as well and try to come up with a plan for water supply planning and water distribution. And then there's some other recommendations that you can make about reducing water demand, providing for landscaping, those types of things. And then one of the final things it does is it allocates funding to the Division of Water Resources to provide technical assistance. So you should be able to go to the Division of Water Resources and find out, and they should have information and data and maybe some hopefully model plans that you can go off of. But yeah, the Division of Natural Resources, they were allocated funds to provide support to local governments in implementing these plans. Again, I think the idea behind it is to just get attention on the water issues in Utah and hopefully get ahead of planning for them. One other related bill that had the same sponsors, and this one's just real quick, it's House Bill 82 or 282. And this one basically says that local governments, so cities, counties, towns, and HOAs. So there's very few bills in the land use arena that address private land use controls. This is one of them. It says HOAs, you can't prohibit people from doing water-wise landscaping. And then you also can't require owners to have lawn in areas less than 8 feet wide, which, as we understand it, means park strips along the street. So again, just more provisions to kind of help to reduce water consumption and encourage water-wise landscaping. So,
all right, House Bill 242, secondary water metering amendments, is another big one to be aware of, as it will require, you know, everybody to take some action if they haven't already. It's, in a nutshell, requires basically statewide secondary water metering by 2030. And the way that they plan to achieve this is they provided some grant money available to help cover the costs of putting in those systems, as well as some fines for failure to not meet that deadline of 2030. So what the bill does is it provides here on the bottom half of the screen, starting with this year and next year, if you apply for grant money and you're purchasing and installing that infrastructure or those meters within the next 2 years, then you can get 70% of the project costs covered. And then for every year up to 2030, that percentage decreases down to 10% in the last year. And then likewise, once we get to that deadline of 2030, if you haven't installed secondary water metering, there's a fee per connection for failing to comply. So in the first year, it'll be $10 going up to $50 per connection for failing to comply by 2034. So definitely something important to be aware of. It does have some exemptions, including counties of the 5th and 6th class. If there's certain elements meant that, one, you have to ask for the exemption. You can't just assume that it will apply. You have to establish that putting in all of these systems and the cost to do so is going to exceed 25% of your total operating budget. You have to agree not to add any new connection on or after basically the date that this bill took effect. And then within 6 months of asking for that exemption, you have to make a conservation plan. In other words, if the state, if you're not going to be able to meter your water, right, the state still needs to know how you plan to conserve water on your own. And so you have to annually report on that plan and be subject to evaluation from the DWRE. And then other than counties of 5th and 6th class, any secondary water supplier could be exempted under certain circumstances, including that you can't find a manufacturer of a meter that will warranty the meter because you have some specific problematic water, I guess I should say, is if you can't get a meter that's going to be warranted, then you don't have to do it. Or and then you have to meet some of those same requirements, meaning a conservation plan and annual update.
Okay, so House Bill 118, Wetlands Amendments. Casey Snyder, Representative Snyder, was the sponsor of this bill. It was kind of an interesting one, I thought. So it requires collection and publication of wetland data and study of the viability of an in lieu fee program for wetland mitigation. So as I understand it, the problem that he is seeking to address is you have, when development occurs, sometimes you're impacting wetlands. And so the federal government, the Army Corps of Engineers, they require mitigation of some sort, whether that's some sort of on-site mitigation or finding wetlands off-site. That's kind of how things have typically been done in Utah. And it's really done on this case-by-case ad hoc basis. And the problem that Representative Snyder identified was sometimes you're left with a few cattails in the middle of a parking lot, and it's just not a useful or effective wetland solution. And the Army Corps of Engineers has an in lieu fee program that allows for basically wetland banking, as I understand it, where you can identify a larger area, a more meaningful and useful area of wetlands. And then as a project happens or occurs and wetlands in that area are reduced, then you can, move the wetlands by credit. You can purchase credits from this wetland bank to make up for the wetlands that you're taking away. And so I think UDOT's used that program, again, on a case-by-case basis here for different projects that they've done. But what Representative Snyder wants to look at is whether or not that could be done on a larger scale basis in Utah, on a more regional basis, so that where a developer is ready to develop and they're going to be impacting some wetlands, they can have options. They can either do on-site mitigation if that does make sense. They can choose to do their own off-site mitigation, or if neither of that looks feasible, then they can go to the in lieu fee program. They can buy credits. They can move their wetlands to that area and then move forward with their project. So the question is that feasible? Will that work? And so this bill, I guess, is intended to pursue that and consider that. So the first thing it does that local governments need to know about is anytime a land use authority, planning commission, staff, council, whoever it is that's approving permits in this land use permits, whenever they approve or consider a permit that has to do with wetlands, and they have to send a copy of that permit to the Utah Geological Survey, who will publish that permit on its website. So they're gathering data about what's going on presently with wetlands. And then it also requires natural resources to form a committee, and they're going to study the viability of this in lieu fee program. And then they're going to make a recommendation, I think in the fall of this year, to the Natural Resource, Agricultural, and Environmental Interim Committee. So we'll see where that goes and keep an eye on that one.
House Bill 177 is another quick bill. Basically, it's no more shallow wells without a permit. So obviously to dig or drill a well, you need a permit to do that project. And what the state engineer has done is, by administrative rule, they've exempted shallow wells, which are defined as 30 feet or less, from needing a permit to dig or drill the well. And the problem that's created is what we call in the law, often the tragedy of the commons, right? When you've got a resource that's available to all, and it's prone to overconsumption, right? So what's happened is, where there's certain communities that have a really shallow water table, right, that falls within that 30 feet or less, people have gotten the mistaken assumption that they can simply put in a well. I mean, you need a permit for the actual drilling or the digging of the well, but people have thought that any well under 30 feet, you don't need to have any water rights for that well, and that's not the case. You still need the water rights to have the well. And so they've nixed that internal rule that allows that exemption. So any well needs a permit to be dug or drilled at this point. Kind of trying to save that water loss where we can.
Okay, so those are kind of the water-focused bills. Now we're moving on to more land use and development specific bills. These first two are kind of just procedural in nature and related to what local governments do in the business of land use, but they're not specifically about land use. The first one, House Bill 22, well, the second one is. The first one, House Bill 22, Open and Public Meetings Act modifications. I guess you could call this one lessons learned from electronic meetings during the pandemic. So the legislators basically looked at it and said, hey, these are things based on the meetings that we've had that we think should go into law. What does it do? It establishes conditions under which a remote member is included in calculating a quorum. So you just have to identify, hey, is a quorum simply those people who are present in person? Does it include people who are attending remotely, if it's hybrid or if it's all electronic? You just have to identify what constitutes a quorum when you're holding a public meeting. And then this is an interesting one. The example was given is that the members of the body were voting or taking action, and someone's camera was off, and they heard a spouse come on and say, so-and-so is going to be voting this way. So what it does is it prohibits proxy voting. It prohibits someone else from voting for you, unless you have statutory authorization to do so, and that body adopts by resolution, rule, or ordinance how they're going to do proxy voting. So I assume that if you have statutory authorization, you do. I'm guessing most entities will not have statutory authorization to do proxy. So in general, no proxy voting by electronic means. And then also it just puts in a requirement that if a vote is in an electronic meeting and if it's not unanimous, then you'd have to take a vote by roll call, which I think maybe all of us could appreciate that. I think we've all been in a meeting where you hear a bunch of yays and then maybe one or two nays, or maybe a whole bunch of yays and only one or two nays and one or two yays. And everyone's trying to, figure out where the yellow outlines are and who said what. If it's not unanimous, you have to take the vote by roll call. Senate Bill 184, this was Senator Dan McKay proposed this one. Apparently up until now, subdivision plats were the only instrument that could not be recorded electronically at the recorder's office. Now everything can be recorded. So everyone is probably very familiar with subdivision plats. Once everything gets approved, you go print the Mylar. It's a big plastic sheet, and if there's needs, and everyone knows that getting signatures is a pain, right? You have to go around to all the different entities, the utilities, property owners, whoever needs to sign it under the local ordinance, and sometimes it can be a real pain to go around and get all those signatures. And then if you need to change something after it's been printed, we've used that little tool, right? That like scratches off the ink from the Mylar, and then you write it in with a Sharpie, or in some cases you have to go print an entirely new Mylar. Those, as Senator McKay put it, were things we just kind of all dealt with, but the pandemic really brought to the fore how inconvenient it can be, especially when now you're taking it to trying to find people's houses and those types of things. And so that was enough impetus for someone to propose a bill and to say, hey, we need to come up with a way and figure out how to allow for electronic recording of plats. So the bill, as I understand it, kind of leaves it up to each individual county recorder to decide how they're going to do it, how they're going to approve and get the signatures and those types of things. But by January 1, 2023, county recorders need to be accepting electronic plats and can no longer require the good old fashioned Mylar. So something to be aware of.
All right, now what we consider to be the big bill of the session each year is the annual update to the Land Use Development and Management Act, both for cities and counties, or the LUDMA update. There was a big laundry list of things that it did. I've numbered them all here, and we'll just walk through briefly some of those by kind of grouped by category.
And for what it's worth, maybe I'll throw in here. So again, every year the land use task force meets, and they kind of, this is considered the land use task force bill, right? When the stakeholders from what they refer to as the Property Rights Coalition, developers, home builders, realtors, meet with, people from the local government side, counties, cities, special districts, towns, and they try to identify areas that need to be addressed. And this year's bill, in my estimation, had a lot of really good clarifications in there. Nothing super ground shaking or impactful, but definitely a lot of good stuff to know about and be aware of as you're doing your work.
So to start, some bills about both annexation and disconnection of a municipality. So with annexation, the code allowed for protests to annexation petitions, to be filed by certain parties, usually those that are property owners within the area. And those people that file a protest have to exhaust their administrative remedies before they can file a challenge in court to the annexation petition. Well, so Tooele County had a recent lawsuit over some annexation into URTA, where a citizen group challenged a petition for annexation into URTA. And but because the citizen group, wasn't necessarily comprised of just or only, property owners within that area, they didn't file a protest, but they filed the lawsuit as just a concerned citizens group. And the district court in that case eventually allowed the citizen group standing to bring the lawsuit, saying that, the statute doesn't specifically say anything really about standing for this lawsuit. So they have alternative standing to sue, kind of in the absence of that statutory reference. So this is kind of a response to that court action and clarifying that the only people that have standing in a lawsuit challenge to an annexation petition are those that are the parties that can file a protest. And in fact, they do have to first exhaust their administrative remedies of filing that protest before they can then file a lawsuit. On the other end of it, on disconnection, there were some changes that really just kind of changed what notice goes out to whom. Previously it was, notice would go out to each owner of real property within the disconnection area. But as for residents, maybe those that are renting are not the owners of the property, but live in the disconnection area, their notice was either left up to, the option of mailed notice or just simply newspaper notice or, posting around in public places. And so now it's changed that so that mailed notice has to go to every owner of real property and every residence within the disconnection area. Some procedural changes to LUDMA in making a zoning text amendment. Notice of that now must include a summary of the effect of the proposed modifications, and it has to be written in a way that's understood by a layperson. So think of, initiative or referenda petitions have to have a kind of a summary of what what it does, right? So you now have to provide that summary within the notice of a text amendment. When you're amending public improvements in a subdivision, it now requires a public hearing and an opportunity for those that receive that notice to make public comment, or I guess just comment at that meeting. As far as subdivision plats and plat amendments, surveyors who the text before basically said that they had to prepare the plat, right? Now it says that they can now simply reference an already existing recorded plat rather than coming up with, you know, a new plat or an amended plat. And then for condominiums specifically, added this language that municipality or county acting as land use authority shall approve a condominium plat that complies with the requirements of Utah's Condominium Ownership Act, unless the condominium plat violates a land use regulation of the municipality. And so we say, well, wouldn't that already be the case? But, you know, maybe it was somebody could sleep a little better at night having that in the code that says that don't approve things, or you need to approve things that are compliant. And I think that for the most part, we already understand that. Some definitional changes, as well as some tweaks to the court standard of judicial review of land use decisions. The definition of land use decision under LUDMA, this bill removed the reference to enforcement of a land use regulation, land use permit, or development agreement from the definition of land use decision. You know, that may have some implications. We haven't really dug into whether that really substantively changes a lot of what we do in our office, right? Because our office is, when we do advisory opinions, we're specifically reviewing land use decisions, right? And historically, we've told people that, you know, if your issue with what the government has done is after a permit is issued, you know, either some sort of enforcement issue, right? That's typically not something that we review, but there's some nuances to that, and so we haven't really seen exactly what this might change, if anything, of taking that reference out.
Give us a call if you have a question.
Right. Exactly. As far as non-conforming uses and structures, you know, the code has said that the burden is on the property owner to establish that, and this is added that clarified that they have that burden and have to meet that burden through substantial evidence, which may not be limited to municipal or county records. So in other words, the same standard that the county or municipality have to meet to, you know, justify certain land use decisions, that is the same evidentiary standard that a property owner has to meet to establish a non-conforming use.
Which I view that one kind of as a clarification, because I think case law had already outlined this, and now it's just being put into the statute so everyone can find it easier, hopefully. So,
and then as far as judicial review, after administrative remedies have been exhausted under a land use appeal, you know, and now says that, you know, the court, the existing language was the court shall presume that a final land use decision of land use authority or appeal authority is valid and uphold the decision. They've just simply removed and uphold the decision. I don't know that that necessarily really changes anything. It just makes it a little more succinct, and maybe that removes some sort of mental block in some instances of you know, the court's review of decisions that are arbitrary and capricious or illegal. And to that effect, they've added basically one element of what an illegal land use decision is considered to be, and that's something that conflicts with the authority granted by LUDMA, which again is not necessarily changing the law, but just clarifying the codification of existing law. Now, some of the substantive changes that do in fact change some provisions of LUDMA. Last year, you may all remember that that House Bill 409 had added a 10-year vesting rule for new subdivisions against subsequent land use ordinance changes. In other words, if a subdivision is approved for the next 10 years, the city or county can enforce a change in its zoning laws when someone comes in for a building permit under that subdivision. And this bill has now completely taken that out. But because it was the law from May of 2021 to May of this year, you all need to be aware that any subdivisions that were approved in the last year were approved under this valid law. And so for 10 years after that subdivision was approved, there will be a vesting against any changes to your land use code that would apply to a building permit. So keep a copy of your code. I know that most entities will already have historical versions of their code, but we've run into instances where maybe a historical code has not been kept or readily available. So everybody needs to keep a copy of their code as it exists in this last year, at least for the next 10 years in case this issue comes up. Some other changes are it's added a section about moderate income housing and when that can be included as a condition of the land use approval. And that is whether it's part of a development agreement or the local code provides some sort of incentives that the applicant is taking advantage of on a voluntary basis, right? Or if the applicant doesn't, take advantage of these incentives or doesn't willingly enter into a development agreement, this provides that the local government can't take that decision not to do moderate income housing into account when making a land use decision. In other words, you can't deny somebody a land use approval solely for the fact that they didn't voluntarily agree to a discretionary moderate income housing provision, right? And then that doesn't apply if the local government is already imposing a resort community sales and use tax, and they have an ordinance about moderate income housing that's basically had been in place before this bill took effect.
Hey, Rick.
Yeah.
Real quick, do you want to take questions as they come in, or would you like to wait and hold those until the end?
Well,
Go ahead. Yeah, let's hear it.
Okay. Someone is asking for an example of substantial evidence that is not municipal or county records.
well,
I mean, evidence can be anything,
Yeah.
really. Anything that serves to prove or disprove the matter asserted, So, I mean, I guess an example would be an expert report, like a traffic report or a soils report, things like that. Testimony of an individual, frankly, if it's credible and relevant and factual, can be evidence. So evidence really can come from any relevant, credible, factual source that helps to support the decision, really. So,
Good question.
And just to chime in on that as well, it looks like Roger Baker chimed in on that and gave a definition. Substantial evidence is any quantum or quality of evidence that convinces a reasonable mind of a conclusion.
Yeah. And as far as the standard goes, that's thanks, Roger.
Yeah, any other follow-ups to that or?
Since we broke for questions, we had a question. So cities are prohibited from adopting an ordinance that requires a portion of any development to be moderate income housing.
Yeah, so here's the standard. I mean, it says that they can only require a certain number of moderate income housing as a condition of approval if it's either, part of a development agreement. So if there's already a discretionary system in place where the developer is kind of negotiating certain terms with the city, right? And that can't be required, right? The city can't require development agreement as the only way to get land use approved, right? But if they're taking advantage of like an overlay zone or something where a development agreement is part of that process, then the municipality can obviously say, we want a certain number of moderate income housing, assuming that there's some other way that the person can use their land under the existing code that doesn't involve, a development agreement. So I think this is all about, moderate income housing is not something that can be forced in every instance on a development, right? It's available if the developer wants to take advantage of certain, exceptions or incentives that the code provides in exchange for, providing modern income housing.
Thank you.
Another two quick ones, cities and counties can now adopt a regulation that specifically says that combining two lots is not considered a subdivision that would require a plat amendment. And then boundary line agreements, this has been something that's kind of been confusing over the last couple of years with certain changes. And I think this really helped kind of clarify, because we had basically two parts of the Utah code that address boundary line agreements. There were some sections in LUDMA as well as another provision in the real estate title of the Utah Code. And this is now kind of repurposed what each of those, and so it's basically said there's two different kinds of boundary line agreements. And so the ones where you would comply with the provisions of LUDMA are those where the property boundary is known and the property owners are simply just, readjusting their mutual boundary line in exchange for consideration, meaning maybe someone wanted to buy additional land from their neighbor and the neighbor was okay with that and they came to an agreement. That's when you would follow the process under LUDMA. If the purpose of the boundary line agreement is to settle a disputed boundary that's either ambiguous or uncertain, that's when you follow the procedure for boundary line agreements under the real estate title.
Okay, so House Bill 132, so that kind of covers everything with the LUDMA bill, and moving on to the next one, 132 Uniform Easement Relocation Act. This one I think is a really interesting one and provides an additional and important tool. So up until now, and here's an example, we'll just go with the example here. So you have lot A and you have lot B and you have a driveway, and you can see that driveway for lot B, maybe up until some point, it was just used for agricultural, and that right of way, the easement for the driveway hasn't gotten in the way, but now maybe lot B wants to develop, right? Or make better use of their property. It would be nice, right, in that diagram, if they could move the driveway down to the lower edge, and assuming that it wouldn't really impact the utility of the easement, lot A would still have their access. It would still be reasonable access, but then lot B could make better use of their property. Up until now, if the property owners could not come to an agreement, then there was really nothing else that could be done. And I guess the concern that's raised in these cases and that we hear about sometimes is, lot B feels like sometimes lot A holds them hostage, and makes it really difficult for them to make beneficial use of their land, or really expensive. So what this bill does is it was you've heard of model or uniform laws. Some really well-known ones are the Uniform Probate Code, Uniform Commercial Code, Uniform Power of Attorney Act. These are all kind of model codes that the Uniform Law Commission, which is a really old organization, puts out and says, hey, these are best practices. And so they created this act, and it provides an alternative for court-ordered easement relocation in cases where those affected can't agree to terms, and encourages flexibility and cooperation. So it basically creates a process by which, if the property owners can't come to an agreement, then in this case, lot B can go file a lawsuit, and as long as they, in short, maintain the utility of the easement and don't affect the value of the property who holds the easement, then they cover all the costs for doing so, then they can get a court order saying, yes, we can move this easement. So the idea behind that is you preserve everyone's interests, and you also allow the property owner, the servient estate, right, over which the easement runs, to be able to make better use of their land. So this might be useful for a lot of developers and owners who are trying to move easements and make better use of their land when they're negotiating with individuals.
One last thing for this audience, though, the thing to keep in mind is that this does not apply to public utility easements or municipal easements, basically. So we bring this up so it may not directly affect any easements that you have as a local government, but I'm sure you'll get lots of questions from property owners either wanting to move a utility easement or do something under this act, and this act doesn't reach those situations, but you'll most likely encounter that.
Thanks for pointing that out. It does apply, however, to prescriptive easements potentially. You can, through this process, move both express and prescriptive easements, but Rick's right, you can't move, someone can't go move their public utility easement this way, so.
So a couple of bills regarding Utah Lake. House Bill 232 created the Utah Lake Authority, which is a state, basically land use authority. We've seen recent efforts where the state is getting more involved in certain land use issues. They've created the Utah Inland Port Authority, right? This is another similar entity. It's a state level land use entity to deal with managing Utah Lake and making some decisions there. whereas previously it was a 15-member Utah Lake Commission that really was struggling, really getting any consensus on what to do with the lakes. And now it's centralized that authority into one state level land use authority. What House Bill 232 did not do, though, is address this Utah Lake Restoration Act that was passed 2 years ago in 2018, which led to some controversy with basically that bill at that time was allowed for a way to receive bids on private projects to aim to restore the lake, and in exchange the Division of Forestry, Fire and State, who controls the lake bed, could basically divest some of that state land or that state lake bed land to that private entity in exchange for them restoring the lake. And this resulted in a couple of interesting proposals, including dredging the lake and building up private or building up these islands that with roadways across the lake. And in response to some outcry into some of those projects, House Bill 240 kind of added some additional process on those types of projects to kind of put a little more people at ease as far as making sure that there'd be a lot of oversight. So any project that would be approved like this, it has to be approved by the entire legislature, both House and Senate, and the governor, and has some certain standards.
Okay, in the interest of time, House Bill 462. This is a pretty big bill. Housing affordability, it's a big issue in Utah, and it has economic impacts. And so the legislature is really concerned about it. You may remember from about 5 years ago, I think now, that Senate Bill 34, a lot refer to this as Senate Bill 34 plus. And I'm not going to reinvent the wheel with this one. The League of Cities and Towns, they have a lot of great resources. I kind of reviewed their website and the resources they have in preparing for this presentation. And they have some great explanations. They have some resources. They've done a ton of great trainings that you've probably attended about how to implement all the new requirements of House Bill 462. The thing with housing affordability is, if there was a silver bullet, everyone would be doing it, right? To keep prices affordable, but no one's found that silver bullet. So I think smartly, Utah's approach is, well, let's try everything, And so some of what this bill does is it expands available menu items for the moderate income housing element of your general plan, and modifies some of the reporting requirements. It also provides some resources to the Department of Workforce Services. There is a new thing for those communities with REL or BRT. And I'm guessing if you're one of those communities, you're already working hard on this, that you do station area planning. And again, we'll make these slides available and distribute them. So if you want to refer to them later, Jason, you're welcome to email them out or get them to your people, however you'd like. But yeah, so for those communities with rail or BRT or any fixed guideway public transit stations, you have to do stationary area planning that considers moderate income housing. A few other quick changes there. A question that's come up since the legislature last session said, hey, in at least up to 75% of your residential areas, you have to make internal ADUs, accessory dwelling units, a permitted use. The question's been coming up, well, hey, can we charge impact fees on those new units? So this clarifies that local governments may not charge impact fees on an IADU established in an existing home. I guess it's determined that that doesn't increase the impact on public services enough to warrant a new impact fee. And then for the Point of the Mountain State Land Authority, it requires the authority to incorporate affordability, housing affordability into a strategic plan and report to the Unified Economic Opportunity Commission, which is a commission commissioned by the governor, and kind of in many ways has become the de facto body for recommending growth policy in the state to an extent.
Quickly related to affordable housing, one method to kind of approach that is also, as mentioned, public transit projects. So the housing and transit reinvestment zone amendments, this was again another bill that was passed last year that kind of created these zones, and this bill simply just added a few more requirements, kind of further limited when you can do an HTRZ. There puts a certain cap within the county, so there's only 8 allowed 8 light stations allowed in any county and 3 BRT stations allowed in any county. And you have to have your zoning, basically ready for that kind of a zone for the underlying, area. And then just add some specific requirements about the size of those zones as it relates to specific types of transit stations, either commuter rail, which is like front runner, light rail, which is UT or tracks, and then obviously BRT or bus rapid transit. We've got one example down in Orem and Provo and another one coming in Ogden.
So again, we want to take some questions and we'll put up our information at the end here. So please reach out to us, email us if you have specific questions, but in the interest of taking some questions and we're running up against time, this one is real quick. Just in short, it requires a condemning entity to get an updated appraisal before making a settlement offer in the course of litigation if more than 90 days have passed since the time of the appraisal. The idea being that sometimes litigation can take some time, especially in today's market, the price can change, the value of property can change. And so this is intended to address that a little bit.
And then lastly, one short bill, the recreation infrastructure amendments. This essentially just creates a fund that you can use to fund certain recreational facilities, which, can include anything from, water sports, snow sports, a state park, golf course, sports field, trails, all sorts of things. And it does include, the fund can be used for the acquisition of land and right of way or an easement. And while, Utah's code on eminent domain places certain restrictions on recreational uses, I think there are some crossover on, technically it sounds like, eminent domain could be used for some of those recreational projects. And so maybe that fund would essentially be able to be available if there's a use of eminent domain. But I think for the most part, it's the funds available for voluntary acquisition of certain recreational facilities.
And then sometimes we like to go over some of the failed bills, just so you know kind of what is in the minds of the legislature or some legislators, and things that might come up. Again, we want to get to questions. So again, eminent domain is ever a hot topic. That was addressed a little bit. There was some issues about initiatives and referenda. Our office, we get a lot of calls on this kind of thing right now.
And I think the move out there is just, because there's been increased use of initiatives and referenda, is these bills were trying to make the process a little easier to obtain a successful, petitions to get on the ballot, and both of those measures failed. Some
failed. And then there's short-term rentals. That's always a hot topic. If you have questions about it, give us a call. There were a few bills that were presented but didn't pass. And then there were a few bills related to our office that we were going to touch on for the 5th time in the existence of the office. They tried to give us authority to mediate and provide advisory opinions on HOAs, but that didn't gain traction, and it ultimately failed. And then there was another bill that would have turned our office, as Will Summercorn puts it, into the land use police, where we would
required to review
all the different, pretty much any action a local government took on anything related to land use. I think that's just related to this sentiment that, hey, state law says this, but local governments aren't doing it. So just something to be aware of, and it's probably best that one did not pass this session. But yeah, there's our contact information. And like I say, we spend a lot of time with people on the phones. If you have specific questions, please reach out to us. We'd love to talk to you. I know we've gone over a little bit, but we're happy to take any questions right now as well if there's time. So
awesome. Thanks so much, Jordan and Rick. Great information, folks. If you've got questions, type those into the chat box and we'll answer those at this time. Just a couple of things as we're waiting for all those questions to come in. We will be sending out the slides from this presentation to everybody that signed up, as well as we're recording the session, and it will be on our YouTube channel probably this afternoon. So if you want to share that with others who didn't get it today, here's some questions that we have. It looks like this is more of a statement. It looks like how HB 303 prohibits inclusionary zoning ordinances that require affordable housing components.
Thank you. Yeah, we didn't get that one in here. Thanks for bringing that up.
Okay. Let's see. Oh, and I think the other questions that I had so far were just about the recording and the slides, and also your contact information. So thanks for ending with that slide.
Excellent.
Just as we're about to wrap, I'm not seeing other questions there. To me, changing the priority for electrical generation, that's a major shift, isn't it?
Yeah, I mean, it's obviously a very important and very large use of our water already, right? So not having that already as a priority, that in the case of a water shortage, you can imagine that, I mean, we don't want to run out of water to generate electricity. So
we have those first priority uses. Is there a priority among those? Is culinary water, does that supersede electrical or firefighting, or they're all primary uses?
No, I mean, my understanding, the text of the code was simply just, it kind of, that's why I said it, there's basically there's two tiers. It's those three: drinking, sanitation, and fire suppression are all listed together. And I don't think that there's any order among those. I think that's all just grouped together. But the secondary priority for agriculture, that is subject to that first priority. And I think that this is all another reason why the state engineer was basically directed to perhaps study which among these three would have first priority, or how do we further define how we actually put this in place? Because I'm not aware that we've ever really needed to rely on this yet. So I think that that's kind of where we're going. So
Jordan, Rick, thank you so much for this great information. There's just so much that distills out of that legislative session, and I know there will be a lot of questions there. So thanks for ending with your contact page there, and I really know that these folks are willing to talk to you about these things, and they're very approachable. So thank you once again for the presentation. Final words.
Thanks for having us. It's always a good time.
Thanks, folks. Everybody go out and have a great day.
thank you.